Good morning, everyone, and welcome to the DIFC Courts. This pre-trial review is in the matter of case number CFI 055-2020 and is being held by way of video conference before His Excellency Deputy Chief Justice Ali Madhani, appearing from Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry in Dubai on judge's directions. The claimant is represented by Hadif and Partners, and the lead counsel is Mr. Karim Mahmoud. The defendant is represented by M.B. Kemp, and the lead counsel is Mr. Salah Mato. Will the judge and the parties' representatives please confirm that the situation is as I have stated?
I confirm that is the case on behalf of the claimant.
I confirm that's the case on behalf of the defendant.
Thank you, Saeed.
Thank you.
Again, very good morning to you. First of all, I'm terribly apologize for my voice because I got very bad flu. Hello, do you hear me? Do you hear me clearly?
Yes, we can hear you, Your Excellency.
We can hear you.
We hope you're feeling
okay.
better, and we're very grateful for your assistance today.
Thank you, Mr. Mata. That's very kind of you. Well, I guess we do have a straightforward pre-trial review. We just need to hear Mr. Karim, if you brief us about the progression of the case and
Yes, Your Excellency.
application you want to make. Yeah.
Thank you, Your Excellency.
Mm.
Just as a point of quick housekeeping, the claim form that was automatically uploaded in our pretrial bundle was the original one and not the amended claim form. So while we have the relief sought in the amended claim form is different, I just wanted to highlight that to the court. For today,
Well, I remember
parties,
you had the court permission to change the statement of your case, isn't it, at some time?
That's correct, Your Honor. We don't know. I think it was automatically uploaded. Both are on there. We have amended it, but when we uploaded the pretrial bundle, it seems the original one was attached to it. We did not attach it. I think it was an automatic process.
Said, would you take note of that, please? I'm doing so. Yeah, that's
Yes, of
good,
course.
Mr. Karim. We have taken note of this. But actually, I think you have access to the bundle, so you could yourself, I mean, do the necessary work as well. You could like withdraw it and then you resubmit the proper claim form.
Okay, we will certainly look into that after this hearing and try to remedy that today.
I'm sure Said would be here also to help you, Adrian.
Excellent. We'll certainly do that after the hearing, Your Honor.
Yeah, the next matter.
So, as it relates to the proceeding as a whole, I raised that issue because the declaration that has been amended by us essentially calls for a recognition that the defendant has breached the terms of the loan agreement, and there's been several proceedings to date, and I think we've gotten to a stage where the defenses and counterclaims relied on by the defendant are no longer being pursued. So I think in terms of efficiency of the court and for the parties, particularly the claimant, it would be helpful today to sort of discuss what is still at stake and what is to be determined at trial.
I mean, but you would deal with this through your skeleton argument, I guess, yeah? So everything would be put in context through the skeleton argument, I guess. We wouldn't need any amendment of anything. Maybe just sort of some withdrawal or from Mr. Mato.
Yeah, I believe if the witness statement last submitted by the defendant, from the claimant's point of view, makes admissions that there is no counterclaim or defense to the loan agreement. So for the purposes of this, and I of course would defer to my learned friend on these points as well, but for the purposes of this pretrial conference, limiting the scope of what is to be, what is at trial or what is at issue, I think would be helpful for the court and for the parties.
Yeah, and I'm sure Mr. Mato aware of the discontinuous process and its and the cost consequences related to this stuff. I'm sure he would take the necessary steps to make sure what to proceed. I mean, we would have a clear version of the what's supposed to be subject of the trial.
Your
Yes, Mr.
Excellency, if I may, the parties had conferred on this issue prior to the pre-trial review today, and we had conveyed to the claimant by way of an email and subsequently by way of a discussion or a video call that the defendant, after reviewing the disclosure and in the witness evidence, had admitted that it will no longer be proceeding with the counterclaim because the disclosure didn't support its position anymore. And furthermore, the only issue to be determined is the issue of interest, whether the interest as provided in the loan agreement is applicable based on the position advanced by the defendant. So we have substantially narrowed. I had envisioned we say that we have substantially narrowed the scope of the hearing. The loan amount is no longer at issue. We say that loan amount, for the reasons set out in the witness statement of Mr. Sethi, 8th witness statement of Mr. Sethi, is no longer at issue and it is payable by the defendant to the claimant. The only issue to be determined by way of the trial is the issue of interest, which is a legal issue, we say. However, we have agreed with the claimant that we would have a limited trial, witness cross-examination on this particular issue. So, Your Excellency, that is all we have to say on this, and I hope it assists Your Excellency with respect to the issues at trial.
Oh, that's really interesting information. Well, I see if you can. I mean, well, I'm happy you managed to deal with most of the cases and the principal amount of the loan and things. What I think what's remain is maybe it's not shouldn't be very controversial to a professional lawyer do. So from my perspective, I would urge you if you could do anything like between you the parties to deal with it and sort of mediation between yourself or professional mediation, even if you want if the parties want the court to assist them with independent mediator unrelated to this. I mean, what I could give you the chance, we could put you before one of our either like certified mediators, this is registered with the court, or another judge, expert judge, whoever you want. We can devote like 1 hour, 2 hours maybe for, if you want. I mean, it's just a suggestion. We are committed to the trial. We're committed to hear from you. If you have existed all means of discussion and negotiation, that's up to you. But this court is really, we do care about parties. Now here, I tell you what, our goal, our vision is not to deal with the cases. We are here to provide parties with solution. That's what you need. You need solution. You don't need a judgment. You don't need a complicated, long written judgment. Well, I'm sure that's not your purpose for being here. So Mr. Mato and Mr. Karim have appeared before me, and he knew this DFC court maybe strategy and the judge's mindset as well. We always encourage parties. I mean, for the best of them. You know what I mean? I could have delivered a judgment and I'd find my judgment would travel worldwide and my name. It's not the point at all.
Your Excellency,
Yeah, I want you to be the heroes. You guys, you can convince your parties. I mean, in the back process, well, we can deal with this. We don't need the court. We're better than the court. You know what I mean? That's how you can tell your, each of you can tell the client now you can be a judge until the trial date.
Your Excellency, your wisdom is very much welcome, and I have my instructions on this already, and I was going to submit on behalf of our client. He had suggested, given the fact that the issues have narrowed down to a very specific issue, a mediation could be a way forward, and we will not object to it if the claimant accepts it as a way to resolve this matter, because it will save costs of trial, and it might be a way to end the dispute quicker than envisioned, and we could have an order in whatever means and shape and form for us to basically to end the dispute with certainty for the claimant and for the defendant. We are fine for the claimant to provide its view or to seek instructions on this, but this would be practically a very good solution given where we are at the moment. That's what the defendant's position is.
Well, if I may, Your Excellency, it's something I'd have to seek instructions on. I do know that one of the issues is that it's taken so long to get to this point where there's an acknowledgement that there's no sort of defense or counterclaim to at least the principal amount. And I fully appreciate that the issues have narrowed, and I will seek instructions on attempting mediation. I do believe that because of the time it's taken, that this could have been solved in a different way much earlier, but we are where we are. I will seek instructions. I think for the purposes of today's hearing, and assuming that the hearing does take place and does move on, I also wanted to touch upon the issue of costs, and because there's been so many orders on costs throughout the proceedings, I wanted to suggest a detailed assessment, given that it's not a straightforward process, given that there's been other law firms involved in these proceedings to date.
I see. I mean, then because you have admission now, so you think you're in a better position to ask for it. Yeah.
Your Excellency,
I think just the.
Sorry, please, my little friend, please go ahead.
Please go ahead. Go ahead, Salah. Please.
May I ask you, Mr. Mato, where you practice? Are you practicing here in Dubai or where else? I mean,
No, I'm based in London, Your Excellency.
Oh, you're in London, okay.
But I visit Dubai every 4 or 5 weeks now, you know.
Yeah, but I'm asking myself, I've never seen you here and appearing before me, at least in the DFC court. Is it your first appearance before the DFC court?
No, Your Excellency, I was before you a few weeks ago in
Really?
Fursa matter. Yes.
Oh my God, then I'm sick. That's why, man. I'm very sorry. I'm terribly apologize. Yeah.
No. I'm sure Your Excellency is you know, very busy and face recognition. This is my second time, so I can just say that, you know.
Who was your opponent?
It was
then?
Miriam. I forget her surname. She was also based in London, I think. At that, I think we had it during Ramadan. We had the hearing.
I got it. And I asked her, why didn't you come physically to attend
That's right,
the court hearing? And you said you're already engaged with another arbitration, another case. I got it now. Okay.
Your Excellency has got an excellent memory, so
now it's just come back. Well, actually, I have a virus infection. That's why it's affecting.
I look forward to in person meeting you next time I'm in Dubai. It'll be a pleasure to exchange.
What I'm telling you, we have like the courtroom are busy like before nowadays. I mean, this week it's the 5 days hearing in the court, and next week we have another 4 days hearing happening in the courtroom physically. So we're back to normal.
Well, we hope to do these things in person again, because it's much better to see each other in person.
Oh, well, maybe not with the only interest case, you know. I mean, that would be a lot of cost for you to travel to trial. Like, what do you call it?
No, I fully agree with Your Excellency.
Yeah. You can't add the extra cost to that. Mr. Karim, you're back in the.
I dropped my other computer dropped off, but I'm back.
I noticed, yeah, and then you have a wider view now. We can see all your law firm now.
Well, I just, Your Excellency wanted to make a point on costs.
Yeah.
Whilst we are not, we will not oppose any detailed assessment of costs. Our position would be, given that there are so many cost orders, it might be the best way, practical way forward would be for the parties to reconcile all the costs at the end of the hearing and sorry, at the end of the matter.
Did I hear Mr. Karim said he intended to ask for costs on contingency basis, or he just asked said detailed assessment? I'm
No,
not
he
sure.
just asked for detailed assessment.
Oh,
I don't think contingency was
okay, I'm sorry. Yeah.
Unless I misheard my learned friend. I don't think he mentioned contingency.
I don't know.
Yeah.
I did not mention contingency. I mentioned.
Okay, that's fine.
Yeah,
That's fine.
Yeah.
You have
Your
it on
Excellency,
record now, Mr.
just
Mato.
to move the matter forward, the parties have, should there be a need for a trial, an agreed timetable has been agreed, which is at section C number 1, and it's going to be a very short hearing. The position of the defendant is that it's an issue of interest, which is an interpretation of contract issue as such, a contractual issue, rather than an issue that turns on evidence specifically. So we don't envision there to be a lengthy cross-examination, even though we have set out a timetable for that, is a short cross-examination of the witnesses. If we are able to reach a agreement on mediation, we say that we could perhaps, with Your Excellency's support and with the assistance of the court, reach a resolution of this before the trial date even.
Yeah, I see. But do you think, my question, if things goes forward in regard of the conflict of interest, the interest dispute about interest, I mean, the 3 witnesses can be taken in I think you're putting how long? It's 2.5 hours. Is that practical, you think, Mr. Mato?
For our purposes, it is, Your Excellency. Because it's a very limited cross-examination on the issue of interest and issue of very specific issues of the facility, and that should not take more than the time that we have agreed with the claimant. My little friend perhaps can provide his views as well.
I'm of the same mind, Your Honor. Because of the limited scope, if it does pertain only to issues of interest, then I believe that the proposed schedule would work with the witnesses. In fact, it may be less, but I think it's appropriate to count for the time if needed.
And are these witnesses here in Dubai or they're abroad?
In Dubai, for the claimant's witness is in Dubai. Sorry, defendant's witness. I beg your pardon. My little friend.
Our witnesses are also here.
Yeah, so we will need any interpreters, isn't it? They're all English speakers. Mr. Harish, Mr. Vivek.
That's correct.
That's correct, Your Excellency. All of them are English speakers.
Okay, I see. I think, yeah, it's fair enough. This schedule can be accommodated through a day for hearing. Yeah.
Your Excellency, would it be would it be useful if my little friend can provide his instructions to the court and to the registry on the issue of mediation by tomorrow, so that we can see if Your Excellency can assist the parties to reach an end of this dispute via mediation, if so agreed by the parties.
Well, Mr. Mato, just squeeze him. Tomorrow he might not find his client by tomorrow. It's okay.
I'm happy to see construction. I think tomorrow
Yeah.
will be difficult if I can get until sometime next week. Again, you know,
Let's say Monday, maybe Monday by
Much.
midday.
Monday midday. Thank you, Your Honor.
Yeah, because
Thank you, Your
otherwise
Excellency.
we wouldn't be here for the weekend anyway. I mean, yeah, just sleep on it, Mr. Kareem, and then come back with a wise decision, and that's it. But yeah. I mean, the lawyers can talk all the time. I mean, you can work weekends. It's not a big deal for you. I mean, I think you can discuss things over and over. But I really, if you want the court as help, if you want to do it yourself, that's fine. If you want the court help, that's fine. If you want to move on with the hearings, that's fine. We were giving you options. Option is the strength. It's in your hand. If you want to use it, that's good.
I think, Your Honor, I will see construction. At this stage, we should consider that we'll need to proceed with the hearing. But I will see constructions on that point and see what can be done. I think there will be a concerning consideration of this matter from my client's perspective. I'm sure you can appreciate it's taken a long time to get to this stage, and so they don't want to see anything that would protract. But as long as we can do it in parallel, that's something that I
Yeah.
will discuss.
No worry. But if whatever you agreed, if you agree to settle by yourself, don't forget the discontinuous process and to for the court in due course.
Thank you, Your Excellency.
Well, at the end, then I'm very glad you're halfway through, and I wish you best with the rest.
Thank you.
We're very grateful and thank you, Your Excellency.
I wish to see you in the hearing date in a great shape.
Feel better. We wish you a speedy recovery.
Mr. Macho, since you appear from London, I don't know. I'm sure 9 is a bit early for you. It will be like what, 6 o'clock maybe for you?
No, it's fine. I actually have a very early start. I'm an early riser, so I'm up by 5:30. So 6 o'clock should be fine for me.
Oh, that's good. I wish I can be like you.
I normally go for a run from 5:30 to 6:30, but I can skip that on 23rd.
Oh, okay. That's when you didn't follow the Champions League matches, like Manchester United, Real Madrid, like the last. You just read the news next morning, huh?
It's quite a terrible game
You-
yesterday, Your Excellency, but the best team won, I think.
Yeah, it is. It is. I agree. Okay, that's all we got to say. Unless any of you have any question to the court.
No further questions from the defendant's side, Your Excellency.
None
Okay,
from my
then.
side as well, Your Honor.
Then I wish you all the best. We're agreed Mr. Kareem would update us by midday Monday.
Looking forward.
Thank you, Your Excellency,
All
and
the
we
best.
wish you a
Thank
speedy
you.
recovery. Thank you.
Thank you very much. Appreciate it. Thank you very much.
Thank you.